The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to give us a call at 414-253-2080. That's 414-253-2080. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We can also serve you completely virtually. Please enjoy the video.
Hello everyone, this is Matt with Learn About Law, and in this video I'm going to give you an overview of Wisconsin family law. In the state of Wisconsin, there are only two legal grounds for divorce. The marriage is irretrievably broken, and the assertion of breakdown of marital relationship by both parties. If the parties both have stated in their petition or otherwise under oath that the marital relationship is irretrievably broken, and the court after a hearing shall make a factual finding that the marital relationship is irretrievably broken. The court will make a finding that the marriage is irretrievably broken if the following events occur. Both parties stated under oath by petition or otherwise that the marriage is irretrievably broken. The parties have lived apart voluntarily for 12 months prior to the commencement of the dissolution of marriage proceedings. If the parties have not lived apart for at least 1 year prior to the commencement of the dissolution of marriage action, and only one party has stated under oath that the marriage is irretrievably broken, the court shall consider all relevant factors, including the facts and circumstances that lead to the dissolution of marriage petition being filed, and the possibility of the parties reconciling their marriage and continue as follows. If the court finds that there is no chance of reconciliation between the parties, it shall make a finding that the marriage is irretrievably broken. If the court finds that there is a reasonable likelihood that the marriage can be reconciled between the parties, it shall continue the hearing for 30 to 60 days. If the court case is continued, the court may suggest that each party seek counseling at the end of the next hearing. If one party states under oath that the marriage is irretrievably broken, the court shall make a finding on whether or not that is true. If during the pendency of the dissolution of marriage proceedings in a Wisconsin court, both parties stipulate in writing that they would like to attempt to reconcile their marriage, an order suspending all order proceedings shall be issued, but not to exceed 90 days in length. During the reconciliation period, the parties may resume living together again as husband and wife, and their actions to not prove that the marriage is not irretrievably broken, and the parties do not waive other grounds. For example, that their spouses out of their own free will lived apart from one another. Property division in the state of Wisconsin. In Wisconsin, upon entry of judgment for annulment, dissolution, or legal separation, the court shall divide the property of the parties 50-50. Wisconsin is a community property state. Separate property shall remain each individual spouse's. Separate property is defined by Wisconsin statute as any property shown to be acquired by either party prior to or during the marriage in any of the following ways: as a gift from a person other than the spouse, life insurance proceeds, payments made under an employment retirement account, property acquired by right of survivorship, employment benefit plan, trust distribution, an inheritance or transfer on death account, or payable on death account. If the court finds that refusal to decide separate property will create an undue hardship on the other party or the children, then the court may divest the party of that property in a fair and equitable manner. In order to terminate a domestic partnership, there needs to be a notice of termination of domestic partnership form filled with the county clerk who issued the declaration of the domestic partnership. There is a fee that needs to be paid, and the notice must be signed by one or both domestic partners and also must be notarized. If the notice of termination of domestic partnership form is signed by one of the domestic partnership, the person who signed must file an affidavit with the court clerk stating either of the following: that domestic partner who has not signed had been served in writing as set out in Wisconsin statute, and that notice of termination of the domestic partnership has been filed with the county clerk. That the domestic partner that has signed cannot locate the other domestic partner after making diligent efforts, and notice to the other domestic partner has been made by publication or otherwise. Once the county clerk receives a completed, signed, notarized notice of termination of domestic partnership, the affidavit, and the fee, the county clerk will issue a certificate of termination of domestic partnership. The domestic partner will then submit certificate termination of domestic partnership to the Register of Deeds in the county in which the declaration of domestic partnership was recorded. When determining legal custody and physical placement, the state of Wisconsin will look to the following factors, which look to the best interest of the child: the wishes of the parents, any proposed parenting plan, and has shown by stipulation by the parents, or any legal custody or physical placement proposal submitted to the court at trial; the child's wishes; the relationship between the child and his or her parent siblings and any other person who may significantly affect the child's best interest; the amount of time that each parent has spent with the child in the past, and any necessary changes to the parent's custodial roles, and any reasonable lifestyle changes that a parent plans to make to be able to spend more time with the child in the future; the child's adjustment to the community, home, school, or religion change; the age of the child and the child's developmental and educational needs; whether the mental or physical health of a parent, child, or other person living in a proposed custodial household negatively affects the child's mental, physical, emotional well-being; the availability of public or private child care services; the needs for regularly occurring and meaningful periods of physical placement to provide predictability and stability for the child or children; the cooperation and communication between the parents, and whether either parent unreasonably refuses to cooperate or communicate with the other parent; whether each parent can support the other parent's relationship with the other parent; whether there is evidence that a parent engaged in abuse of the child or children; whether there is evidence of domestic or spousal abuse amongst the parents; whether a person whom a parent is in a relationship with or whom a parent resides has a criminal record, and whether that person has engaged in abuse or neglect of the child; whether a parent has a problem with drug or alcohol abuse. Thanks for watching. To learn more, check out the article linked below. Be sure to leave any questions you have in the comments section and subscribe for more legal content daily.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience, and we serve all of Wisconsin. Thanks again for watching.